I think I'll have stipulated to it, but
Quite frankly, Your Honor, I understand the court's position, but I don't believe there would be anything different with any additional report. We had difficulty gaining his compliance, and I believe Judge Ward ordered him to cooperate with Dr. Zeman, which is how we were able to
I understand. I'm just saying
Okay.
misdemeanors are treated differently for competency, so I just want to
Yes.
make sure that the summary, as I'm now reading through it, is consistent with this being treated like a felony case as opposed to the misdemeanor case where this may have been initially ordered, or a competency evaluation may have been done a year ago. But based on the stipulation, I've now reviewed the entirety of Dr. Zeman's report. Based on that, I'll find that Mr. Green is not competent to proceed, and remand him to the Department of Children and Families for placement before the state hospital for competency training. Specifically talks about they think he can become competent as he has in the past once he's stabilized.
Yes, Your Honor.
You give me an order on that, Mr. Maddox.
I will. Thank you, Your Honor.
Transport.
All right, thank you. We're going to have the next person.
All right, thank you.
Baker.
Gentlemen, we're done. You Baker. Ryan.
Morning, Mr. Baker. So,
Go ahead.
Your Honor, this is Mr. Baker before the court in 25 CF 157, and he picked up a new case recently in 26 CF 422. Your Honor, the court had set this hearing, or Judge Ward, I believe, had set this hearing so that we could determine what the status was with his commitment to the Agency for Persons with Disabilities. I've reached out to them, Your Honor. I reached out to Kathy White, and I also reached out to Tina Baker and Joseph Sanchez. My understanding when I talked to them a couple weeks ago is that there was still a bed available for Mr. Baker. The reason Mr. Baker was never taken into custody with the APD was because he was out of jail, is my understanding, and I guess among all of us, no one ever really followed up with any sort of way to get him to the agency. It's a strange set of circumstances, Your Honor, but nonetheless, as I was working to do that, whether it be transportation directly to the facility or committing him to the county jail so that the facility would actually come and pick him up, he picked up these new charges, unfortunately, Your Honor. The state and I have discussed this. We are willing to stipulate to the fairly recent report in the older case, 25 CF 157, as being a basis to find him incompetent as well. In this new case, 26 CF 422, the goal will be to get him to the agency as soon as possible, Your Honor, and committed so that he can receive the treatment that he needs. I believe that bed is still open and that he could get there. I just need to reach out to them again and let them know that the court has committed him, given that's what the court decides to do today. I do have a copy of the old report, Your Honor, to enter in this new case so that he can be found incompetent and committed to the Agency for Persons with Disabilities, if I may approach.
I do that before information's been filed. This is a
Wow.
for me. I think.
I suppose that's true.
I don't know how that would be a thing. I could file an.
And just for the record, as far as what happened is he was arrested, I believe, Saturday.
Judge Ward at first appearance actually called me, I think, from the bench on Sunday morning, and we talked about this. We wanted to put him on the earliest date we could get him on, which is today. I don't disagree with the plan that you come up with, Mr. Maddox. I just went as far as a procedural issue. Does an information have to be filed before I can consider competence? He's technically not charged by the state yet.
I could put on the record that I will note nunc-pro-tunc the information, and I think that would cover our bases. I think Mr. Maddox's plan is going to be the best one, so he doesn't get released from jail and we end up in the same spot. So,
I agree with the court, Your Honor. That would present clear jurisdictional issues. That was, quite frankly, an oversight of mine in trying to get him to the Agency for Persons with Disabilities this time and make sure nothing falls through the cracks. It is a very new case, Your Honor. I'll work with the state on that, but do you want to What is the next court date we have? The 26th, right?
Yes.
Okay. Well, I've talked to Mr. Baker about it. He is fully on board with going to get the treatment that he needs, so that won't be an issue, Your Honor. It's just about getting them here. So as soon as the state files an information, I suppose what I will do is file since we essentially had a hearing and he's already been found and competent to proceed, I believe we could file a stipulated order to have him transported to the Agency for Persons with Disability for his treatment, and that would solve the need for a hearing as soon as that information is filed. And I will let all parties know that that is what's going on, and make sure that bed remains available given it's still open, which, as I said, my understanding is as a couple weeks ago, it still was. They've held it open for a long time, so.
All right, based on the stipulation, I'll certainly take a look at it once everything's filed in this case, but if you could coordinate with transport, I mean, even if it involves just giving them sort of signature bond or whatever on the cases with the condition that he go to the APD facility, however y'all want to word it, I just don't think I can sign an order finding someone incompetent in the case with the state. And I'm not blaming the state, this case is 5 days old. Probably don't even have all the reports yet. But I think from just a procedural standpoint, it has to be done in the proper sequence.
I agree.
So if y'all want to send me your proposed orders, I'll take a look at them and sign them in the proper sequence.
Forgive me,
Go ahead.
is he locked up just for the new case, or is there some sort of violation of pretrial services that would hold him? Because the state could just no process the case if he's held on no bond for a violation of pretrial services. That would also,
I don't see the actual paperwork from first appearance yet.
because I've had issues, maybe not with APD, but DCF, where there's new charges filed, and that just puts a wrench in what we're trying to accomplish. So I've found in my practice that if I'm able to dismiss the case, then that's going to be the best route. And I have talked to the victims, one of the victims there present, and they have no objection to me dismissing the case so the defendant can go to where he needs to go.
Problem is, when I look them up on the jail's new site, it only shows the new case.
Right.
I don't have a copy of the paperwork from first appearance, so I don't know if his bond was revoked in the previous case. I'm guessing it's now I'm getting the shake of the head from court security that it wasn't.
Yeah, that would be, I don't want to say it would be unusual, but Judge Ward sometimes will and sometimes won't. In a case like this, maybe he wouldn't have.
He was iffy about doing anything.
We're looking at that right now.
Okay.
Just the fact
And I do know
that
that
first appearance paperwork from Sunday is still not viewable on Thursday is a whole other problem.
there's
Let me just see if I got anything on it, Your Honor, while I'm looking through it. Hopefully I did, but.
You may see if here it is. I can find it in the new case. No, his bond was not revoked in the previous case.
I would, if I may, move to revoke the defendant's bond given the new arrest.
Objections to that, Mr.
Well, I mean, I have to, naturally, Your Honor, I have to object. We're all aware of the circumstances that brought Mr. Baker here. Doesn't excuse the conduct, Your Honor, unless there's some sort of insanity defense, which obviously I can't proffer to the court at this point, but I think that would be, I think that should be done at a later time or heard at a later time, Your Honor, depending on what happens with the Agency for Persons with Disabilities. If he's just going to be treated over there anyways, it may be a moot point because he's going to be receiving treatment and committed anyways.
All
I
right, this is what
understand the
I'm gonna
state's
do. I'm gonna
request.
continue to hold him without bond on the new case,
All right.
the 26 case. As far as the 25 CF 157, he's to go to APD. That's been ordered previously, right?
Yes, Your Honor.
So, as part of his bond on the 26 case will be, is that a lockdown facility?
The Agency for Persons with Disabilities, lockdown meaning inmate, inpatient, or
Where he's not going to be able to remove himself from the facility.
I would think so, Your Honor, but I don't want to say definitively it is. I'm not familiar with
Even
their
today, I
different
think is-
agencies.
Your Honor, I was spoke with ADP, and I don't believe that they will take him with this new case pending until it's resolved.
That's why I think, that's why I made the motion.
Okay.
I've ran into this about every time.
So, if, and I'm not trying to, this is not intended to sound like a negotiation, but if the court were to revoke his bond in the initial case with release to APD, your intent, Mr. Sprouse, is to dismiss the case.
I'll dismiss it right now.
No objection.
All
Go
right,
ahead.
so no dismissal to the, or objection to the dismissal. All right, so the state's dismissed 26 CF 422. I'm going to hold him as far as 25 CF 157 to be released to the APD program.
Okay,
And Your Honor, out of an abundance of caution, just to make sure the court's orders are carried out, I'm going to submit another order detailing what has happened here today.
Okay. And for the extent I need to say it, it's basically a bars to bed situation, so it'll go directly from the county jail to the APD facility.
No objection.
All right.
And if the record would reflect a no cross.
No problems, not all problems. All right, does the jail need anything else from us to make sure that it's clear what the court's ordering?
no, sir, not to my knowledge, not right now.
Okay, just follow up, Mr. Maddox, if anything needs to happen. I just don't want this to kind of fall off the radar.
I'll go to my office right
Then I'm
now
gonna-
and get the order done.
All right, I'll be here.
Thank you, Judge.
In fact, I'll probably just bring it for you to sign, Your Honor, if that's all right.
Yes.
All right.
Well, I would rather it go through the system that way.
I'll submit it and bring it.
There's kind of new guidelines regarding electronic signatures and things like that. I'd rather just do it that way. Better paper trail. I have a case recently where a private lawyer brought an order to me, I signed it, and then it seemingly disappeared. And then somehow ended up showing up on the court system later on. So I think we have this, I'm sure, expensive system for a reason. Let's use it.
Yes, Your Honor.
Just email it directly.
Have you excused?
Yes.
I'll go take care of that.
All right, that's
And I've got three more from Mr. Williams.
Mr. Williams.
Yes, sir. Mr. Cohen.
Thank you.
Judge, this is Mr. Cohen. I believe he's scheduled this morning for a bond hearing. He also has a case scheduled for an arraignment this afternoon. I'd like to go ahead and arraign him at this time.
I just handed him his information.
All right, so. Pull that up. All right, so that's 26 CF 213, where he's charged with possession of a firearm by a convicted felon and driving without a valid driver's license. That's a little bit of a difference. That's what he was initially charged with. Because it was a paraphernalia charge, it was driving on a suspended license before.
That's correct.
So what is, you're entering a not guilty plea on that?
That's correct, Judge. 15 days prior motions, trial by jury. We previously did a denial on him February 26 on the VOP, and I think that case is set for call today. I'll ask that case be passed to be handled with the new law violation as well.
So what else do you want to do today?
Judge, I've got him on for a motion for bond reduction.
And that's why I asked, because obviously the difference in court date is if he's in or out.
Yes, sir. Yes, sir. Judge, he's been in, I'll just go through it briefly. He's been incarcerated since his arrest on January 27th. The current bond is $30,000. He's unable to make that. He's requesting a total bond in both cases of $2,000 for a signature bond. He's been employed for 2 years at Ward's Ranch, which is in the area. Resides here in the area with his mother, Helen Cone, 1941 Riverview Drive. She's apparently 73 years old. His income is the income for the family, and he's lived in the area his entire life.
Anything else?
No, Your Honor.
Mr. Sparks?
The defendant's entitled to a bond on the VOP. I think that, given the charges, he does face a 3-year minimum mandatory because it was actual possession of a firearm, which he admitted to in the police report. So I think the bond is appropriate as it sits. And the facts and the circumstances, the defendant wasn't doing anything right on this day. He didn't have a tag on his car. He didn't have a license. He had a firearm, which he knew that he wasn't allowed to have. He admitted to that. So,
He had a glass pipe with powder residue that seemingly was never tested. So assuming one, the state didn't file that charge.
yes. Because it would probably get dismissed if it went to trial. That's a long instruction.
Anything else, Mr. Williams?
No, Your Honor.
All right, so just to clarify, I think in the new case, because the changes in the charges, so he still has a $25,000 cash or professional bond on the possession of a firearm by a convicted felon. Count 2 was not filed, so, and that was an ROR anyway, and then count 3 was previously drive-on license suspended. They had a $5,000 cash or professional bond, now it's no valid driver's license. So I'll just switch that from, well, set a bond on that new charge is an ROR, so it's a $25,000 cash or professional bond on the new case. I'm not going to grant him a bond on the VOP. He's on probation, and there's probable cause to believe that he's committed not only a new offense, but a new felony that involves a minimum mandatory prison sentence.
Yes, sir.
That according to the report he admitted. So, to the extent, your motion to reduce bond in the first case is done based on the fact that the charges have changed. I've done that. As far as in the 24 CF case, the violation of probation is denied.
Yes, sir.
Thank you, Judge.
Given that
So that's going to
is,
be April 29th at 9 o'clock.
thank you, Judge. Okay, let's see you.
Mr. Lee.
You're gonna need to hold that open.
Shoot there.
He's still in the wheelchair.
Lost the shoe.
Oh, okay.
Y'all know who Brooks Gonzalez is?
It does not ring a bell
Yes.
with me, Judge.
That's,
Hey, Mr. Lee, come over here.
Zoom, I just don't know what.
Maybe up a little bit where the judge can see.
that sounds like a South End case that I had previously that was going into Beckwood.
Okay, let me just bring that person in. Well, let's finish up his case, and I'll bring him.
Judge, this is William Lee, 23 CF 957. He's before the court on violation of probation arraignment. A letter of denial for him at this time.
Now will be entered. What would you like to set it for, Mr. Lee?
Judge, let's not set it with subpoenas as yet.
Okay. What do you want to
I do have some people I'm going to be trying to get a hold of, so let's not set it too quickly.
Do you want me to put on the 26th without subpoenas and see what you want to do with it from there?
That's fine, Judge.
Okay. March 26th, 9 o'clock without subpoenas.
Thank you, Judge. Okay, Mr. Lee, I'm gonna try to get a hold of your caseworker and all those folks we talked about. Okay. We're gonna need to go with Deputy Williams.
Oh, you know what? Mr. Gonzalez is there for something that's already been canceled.
Come stand over here, Mr. Matt.
Let me handle Mr. Gonzalez.
Yes, sir.
Mr. Gonzalez, can you hear me on Zoom? Mr. Gonzalez?
Yes, sir, I can hear you. Can you hear me?
Yeah, I can hear you. Mr. Gonzalez, your case was already continued. I'm going to give you the date. April 29th at 8:45 via the same Zoom address you're on now.
Yes, sir.
Have you-
April 29th, 8:45.
Yes, have you resolved your other case yet? Your felony case?
Yes, sir. I'm actually in vet court
Okay.
today. Today will be my first day in vet court.
Okay, so you might want to reach out to the sheriff's office about this case that was already continued, set for 8:45, I think. So they know the result of that, and they may resolve this case with what happened in your veterans court.
Yes, sir. Thank you, sir.
All right, thank you. Have a good day.
You as well.
Mr. Sprouse, do you want to vote for a second? So I can
Yes.
explain it to you.
I think I have
All right, go ahead, Mr. Williams.
Thank you, Judge. Judge, we're here on Mr. Mack today on a motion to compel.
Discovery's never been provided, is that what I gather?
Well, discovery, they've provided a discovery exhibit, but I'd like to point some things out about it from the court. The motion asks the court to take judicial notice of the clerk's file,
Okay, I'm looking at the discovery exhibit.
and I have printed
Well, the day
copies.
after your motion to compel.
Yes, sir.
Go ahead.
So, this, as the court's aware from the record, I filed my notice of discovery October 29th, 2025. State filed their initial information on November 4th of 2025, followed it up with an amended information on December 3rd of 2025.
Okay.
State then filed what purports to be a discovery exhibit on February 25th, 26th, the day after I filed the motion to compel. Here's what I'd like to point out about the discovery response, Judge.
Okay.
The charge went from trafficking cocaine 28 grams or less to trafficking in cocaine 400 grams or more. So it's an extremely serious charge. If the court would look at the discovery exhibit, it lists one witness.
Yep.
If the court goes over to the second page, what I generally refer to as the checklist, it says there are no statements of any person whose name is furnished in compliance with that paragraph. There are no written or recorded statements or the substance of any oral statements made by the defendant, including a copy of any statements contained in police report or report summaries, together with the name and address of each witness to the statements. No written recorded statements of any co-defendant, no grand jury minutes, no tangible papers or objects that were obtained from or belonged to the defendant.
All right,
No material.
I don't think we have to belabor it, Mr. Williams. I understand your point. It sounds like they said there's one witness, there's no objects, there's no statements, there's no videos. Objects, I think, would include whether or not there was 400 grams of cocaine. So, Mr. Sprouse, why don't you give me the state's response?
We have reached out to the one witness that we have listed, Corey Rawls with CPD. He's our contact for this investigation, because I think about every agency that possibly could have been involved in this case was. So we have DEA, we have Okaloosa County, we have CPD as well. Officer Rolls reached out to the AU, the Assistant United States Attorney. AUSA. And he hasn't gotten anything back from the AUSA. So I very much am looking forward to getting the information so the state can provide it to the defense. The reason the exhibit was filed the way it was because we just don't have any of that information. So we were trying to be very candid with the defense. We've said the same thing in every hearing about these issues, but I definitely understand the defense's position.
So is there any reason why I shouldn't grant the motion to concur? There's clearly more information out there, but whoever has it refuses to give it to you.
Correct.
So there may be a court order.
Yes.
And frankly, if it doesn't, it looks like this case is gonna die on the vine.
Correct.
So in your order, Mr.
I
I understand the situation, but if cases are gonna be filed in state court, then federal actors have to give you the information to do so, or otherwise they're gonna end up being dismissed.
I totally understand, Judge.
We're not a placeholder.
Judge, can I ask the court to give me a drop dead date to put in that order? A date for it to be filed or otherwise
I think
disposed of?
15 days should be sufficient.
15 days? Yes, sir.
I mean, technically, this stuff should have been turned over months ago. And again, I'm not blaming the state. You can only provide what they give you. That,
All right, thank you, Judge.
Mr. Mack has had a bond hearing, which I denied before we even knew about all this. But he's sitting here in jail on a case where the government is refusing to provide information as to why he's being held.
I will point out the bond hearing was heard the same day as the charges were filed. The bond hearing was heard the morning before his arraignment.
When was the motion to compel filed?
The motion to compel was not filed until fairly recently.
Okay, so months later.
Yes,
So what the court had stated was, I didn't know anything about the discovery issue
I
until
understand.
now.
No, sir, you
Not
wouldn't
when I
know.
made the bond determination.
No one knew. All right, thank you, Judge.
All right, thank you.
Appreciate it.
Thank you, Judge.
I have some lined up with Ms. Rivers. First one out the door will be Ms. Powell. This is Rachel Powell.
Your Honor, this is Rachel Powell before the court on 25 CF 733. We've reached an agreement in this matter.
I'll just have to print the score sheet.
You got a score sheet?
I'll have to submit after court because I went to the office. It wasn't working this morning.
All right, so. I think I said on Monday, but I know we're not gonna have that courtroom back for probably a couple of weeks. So let's make sure that things are getting done in advance, otherwise it's just, y'all gotta bring them over, I gotta print them. and it's just-
Yes, I apologize. I'll
Yeah,
get that streamlined.
Unfortunately, we don't have forms for guidelines that can come in electronically that I can edit them. So I'd have to print them out, write them by hand, then scan them back in. It's just easier to bring them in person. All right, Ms. Powell, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Can you state your full name and date of birth, please?
Rachel Diane Powell, 4584.
Can you give me an idea on what the points would be?
34 points.
34
Or
points.
34, yeah, points,
Points.
not
34 points. All right, Ms. Powell, you're here in 25 CF 733, where you're in charge with 2 counts of possession of a controlled substance. Those are third-degree felonies, punishable by up to 5 years in state prison. And DUI, which is a specified traffic offense and punishable by up to 9 months in county jail. And possession of drug paraphernalia, first-degree misdemeanor, punishable by up to a year in county jail. Do you understand all that?
Yes.
All right, I've been given a plea and sentencing agreement between you and the state that calls for you to plea as charged, right?
Yes.
Okay. And then on the 2 felony counts, it'd be 2 years of probation. On the DUI, it'd be 11 months, 29 days of concurrent probation, which means it runs at the same time. And on the paraphernalia, it'd just be time served. Your probation would include DUI school, any recommended counseling, 50 hours of community service, a victim impact panel, 10 days vehicle impound, 6 months driver's license suspension, waive costs of supervision, $500 fine. Court costs would be more than $476, right? Because possession of a controlled substance would be
That's correct, Your Honor. I was thinking of the DUI
Yeah.
portion, so it would be the
$615.
$615.
$615 in court costs, $100 PD fee, $50 application fee. Is that your understanding of the agreement, Ms. Powell?
Yes.
Is that what you want to do here today?
Yes.
Have you had a chance to go over this agreement with your lawyer?
I have.
And did you understand and sign the agreement?
Yes.
Are you satisfied with your attorney's advice and representation?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything in return for your plea?
No.
And you understand that by entering a plea, there won't be a trial of any kind?
Right.
You understand that?
Yes.
Okay. And do you understand you're giving up your trial rights, which are on page 2 of the agreement you signed?
Yes.
And do you understand you're waiving all potential defenses to each of these charges?
Yes.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes.
All right. And what is your plea to the 2 counts of possession of a controlled substance, DUI, and possession of drug paraphernalia?
No contest.
Okay. I'll accept your no contest plea is freely, voluntarily, knowingly given. Again, on the felony count, 2 years of probation, concurrent with 11 months, 29 days of probation on the DUI count. No probation, it's just time served on the paraphernalia. DUI school, recommended counseling, 50 hours of community service, impact panel, 10 days impound, 6-month driver's license suspension, waive cost of supervision, $500 fine, $615 court cost, $100 PD fee, and a $50 application fee. I will need your fingerprints, as this is 2 felony convictions and the DUI is required. Then I need you to speak with probation first. I can never see you back there.
I'm here.
And then, so talk to probation first, fingerprints, then you have 30 days to appeal. This is a guideline sentence, 34 points.
Your Honor, probation requests that she be given the entire period of time in which to complete all these conditions.
Yes, but I would like the DUI school done faster than
Correct.
just
I understand.
3 years, so, okay.
Your Honor, it's 2 years.
2 years, you're right. Still,
Get the DUI school done.
let's get signed up for the DUI school, I would say within 30 days, unless it's a financial hardship.
They have to pay for it before they can sign up for it.
Well, that's what I'm saying, unless it's a financial hardship.
Okay, thank you.
All right, who do we have next?
Your Honor, next should be Devin Robbins.
Robbins.
Your Honor, Mr. Robbins before the court on 21 CF 2891 on a violation of probation. We're going to enter a denial at this time. Your Honor, I was made aware this weekend that there was a potential conflict that has been brought to 2 different supervisors' attention. However, no decision has been made at this time as to whether we are to get off the case or not. But I have talked to Mr. Robbins about that, so we may be filing a motion in the future. But as of today, we're going to enter a denial and request a new court date.
All right, I'm open on March 26th at 9 a.m. No subpoenas. Let's get that part figured out. The BOP. All right. Anything else from Mr. Robbins?
No, Your Honor.
Salisbury.
Your Honor, something has just come up with Mr. Salisbury, so if you may have a moment with him. Your Honor, this case was set for a plea. However, there has been a change in the offer by the state, so we no longer have an agreement. So we're going to have to leave this back on the pretrial conference docket.
Is that where he's already sent?
Yes, Your Honor. Or we've
Looks like it's
said,
set
may
for
not.
4/29 at 9 o'clock.
Yes, thank you, Your Honor.
Okay. Y'all get it figured out again, you can certainly bring it in sooner.
Thank you, Your Honor.
All right, thank you.
Tolan.
And Your Honor, I just need to have just a moment with Mr. Toller. Your Honor, this is Derek Toller before the court, 25 CF 1800. We've reached an agreement in this matter, if I may approach.
Let me just make sure I'm clear on everything, because there's some cleanup that we'll have to do here. This is Derek Wesley Tolar, 25 CF 1800, the VOP. Put the VOP, I believe, back in December.
He pledged the original
December
charge.
23rd.
Yes, Your Honor.
Right.
Yes, Your Honor.
And the affidavit of violation came out a week later.
Yes.
And then there was a notice of appeal regarding this plea agreement and sentencing, right?
Yes, Your Honor.
Okay, what's the plan with that?
Your Honor, he's indicated that he would like to withdraw his request for an appeal at this time.
I just want to make sure that it's clear on the record that, because pleading to a VOP based on a sentence that you're appealing is just going to cause potential mess. So you're free to do whatever you want, Mr. Toller. I just want to make sure that it's clear that there's nothing else for the court to do in this particular case, and what y'all may end up doing with the First District Court of Appeal.
All right, so Mr. Tolmar, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. I've already announced your case number. This is a VOP. The plea agreement that you've made with the state, it looks like, is revoke and terminate your probation, 9 months county jail, credit for time served, $100 cost of prosecution, $100 PD fee, and a $50 application fee. Is that what you want to do here today?
Yes, sir.
Is that the state's agreement?
That's a state's agreement, and it is a guideline sentence. He scores 34.4 points.
All right, Mr. Toilet, have you gone over this agreement with your lawyer?
Yes, sir.
Do you need any more time to do so?
No, sir.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Absolutely.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the agreement I've just read off?
No, sir.
You understand that if you admit your violation of probation, there won't be an evidentiary hearing where the state would have to prove how you violated your probation?
Yes, sir.
And you understand you're waiving any potential defenses to that violation of probation?
Yes, sir.
The plea agreement I have is kind of more of a normal underlying offense type plea agreement. Do you have any questions about the VOP process or anything that for your lawyer or for the court?
No, sir.
All right. And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And what is your plea for the violation of probation? Are you admitting or denying it?
I admitted.
All right. I'm going to accept your admission as freely, voluntarily, knowingly given. Revoke and terminate your probation, 9 months county jail, credit for time served, $100 cost of prosecution, $100 PD fee, $50 application fee, monetary to judgment. All monetary to judgment. All right, this is a guideline sentence. He scored 34 points.
Thank you.
I don't think I need fingerprints because he's adjudicated on the United
I was told to tell you that there's a witness here.
Okay, good. I was wondering about that. Yes, Your Honor.
Wagner.
There's Nelson here, Your Honor.
Oh,
Richard Wagner.
okay.
I'm sorry?
I know I've got another one this afternoon too, so.
Yes, Your Honor. Your Honor, this is Richard Wagner's for the court on 23 CF 2526, 25 CF 895, 25 CF 898, 25 CF 899, 25 CF 902. And he filed a request for Nelson hearing. We did previously at the last court date. There was some discussion back and forth, and then the court set it for today.
Okay. So, Mr. Wagner, can you raise your right hand? Do you swear or affirm any testimony you give here today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. We did talk about this a little bit last week on February 25th at your pretrial. One of the concerns is you would also with your motion for the Nelson hearing, you made a demand for a speedy trial. You ultimately kind of withdrew or struck your request for the speedy trial. So we're here for the Nelson hearing. What would you like to tell me? We talked about it briefly, but my concern last time was you weren't very specific in what your concerns are with Ms. Rivers' representation.
Well, just that we haven't been seeing eye to eye.
Okay, again, specifics is what I need. So just so you understand, lawyers can only do what they're ethically allowed to do. For example, they can't file a motion if they don't have a good faith basis to believe in it. And they can't pursue certain defenses unless they have a reason to do so. So I'm not saying anything about what, because you haven't told me any specifics, I'm just kind of throwing that out there and maybe start the conversation here. So tell me what specifically Ms. Rivers has done or failed to do that you've asked her to do in your cases.
Okay. So originally, before the trial, we had spoke about the invoking the speedy trial, not the demand for speedy trial, but I was advised that I couldn't invoke the speedy trial until that 2023 case was resolved. That's why I continued through. That's why I refused the continuance that time and went to trial for it. And she said that I couldn't.
Well, the case you went to trial on was from 2023, and you've been in CAPIA status for quite some time, right? Do I have that right?
Yes, sir.
So you had kind of waived your right to a speedy trial in that case because you failed to appear for court, and once they picked you up
That's
sometime later, we gave you a trial the first time around, right?
Yes, sir. That's what I was saying. I was talking about the other cases.
Okay, so let's talk about those, because I think I had a thorough discussion with you about those, and you had waived your right to a speedy trial.
Okay, I think it's a misunderstanding. I was talking about, I was advised that I couldn't invoke the speedy trial for the new cases because we had the 2023 case to resolve. is what I was
I
talking
believe so. In fact, I remember that there was, at least on my side, quite a bit of concern on how I was going to get all your trials done because you were asking for a speedy trial. And then you ultimately waived that right to a speedy trial, and I can try to figure out the date that happened.
I remember having a conversation about it, but I don't remember exactly what was said. I put in a request for the transcript so I could see exactly what was said.
I can go back and try to listen to them, but we talked about the speedy trial last time too, and I didn't think that was an issue we were discussing today. So I didn't really prepare for that part.
You know, it was just one of the things, and I asked her to invoke speedy trial, and then the last time we talked, I asked her to demand for speedy trial. You know, I'm been in jail, I'm ready to have it done with.
But we just talked about this last week, Mr. Wagner, and you can't have a speedy trial and also try to get a new lawyer. I mean, these are constitutional rights, but if you're waiting till pre-trial conference to bring it up, how am I supposed to have the hearing, get you in, and potentially get you a new lawyer to have you ready for trial, say, within 2 weeks?
Well, the reason that I did the Nelson hearing is because she never said nothing about it, never made the motion to go to trial or anything, never said nothing about
There's
it.
no motion to go to trial. We showed up last week on February 25th for your pre-trial conference. That's when cases get set for trial. You wanted to address the Nelson issue first. And so I said, we can have that. We can't have it at that time because that's not what that docket's for. We just don't have the time to put into those because we have, I think that docket had almost 150 people on it. And that's why we set it for today.
Yes, sir. Well, before I put the Nelson hearing in, she come up to the jail and see me, and I told her I wanted to demand for the trial then.
Okay.
She still hadn't done it. So that's the reason I put the Nelson hearing in.
Respond on that.
Your Honor, I set the cases, several of the cases for depositions. My intention is to complete the depositions first, then I'll be ready to go to trial. He's previously waived that right. Once you file the speedy trial, you're saying you're done. You're saying no more information. You're ready. And that is.
I'm pulling up the rule right now so I can make sure I wrote that.
I speak, or you want me to wait?
I'm just looking something up because I want to make sure that all right, so I'm looking at rule procedure 3.191, paragraph G, demand for speedy trial. An accused is bound, which means you're in jail like you are. A demand for speedy trial binds the accused and the state. No demand for speedy trial shall be filed or served unless the accused has a bona fide desire to obtain a trial sooner than otherwise might be provided. A demand for speedy trial shall be considered a pleading that the accused is available for trial, has diligently investigated the case, and is prepared or will be prepared for trial within 5 days. So what Ms. Rivers is saying is she's doing depositions in your case to investigate it, be prepared for trial. And if you file a demand or she files a demand on your behalf, she's saying, I'm ready for the trials in the next 5 days on 4 cases.
All right, well, that's, I understand that, but what I'm saying is that she's not explaining that. This is the first time she said that from, she's never explained that to me. That's the issue I'm having is we're not seeing eye to eye. She's not explaining these things as they're going through. I have no clue what's going on.
Okay. Ms. Rivers, have you explained this to me?
Yes, Your Honor, and we've been over, well, I've tried to go over everything, and even fact specifics involving his case, try to show him videos. Sometimes he's interested, sometimes he's not. And the speedy trial thing is what you see in the courtroom is how it is in discussions with him. It just becomes this circle and we never get anywhere. But I did tell him that it was my intent to have the depositions and to go forward. But when you keep getting 2 different answers, I just, as I mentioned before, it's like I have to prepare this on my own. This is completely separate and apart from him because of the information, feedback, and lack thereof that I get from him.
Okay, so basically, what I need to hear from you, Mr. Wagner, is do you want Ms. Rivers to continue investigating your case and doing depositions, or are you saying, I want to have a trial next week?
I'm saying I want to have a new lawyer.
That's not the answer to the question. You're just saying you want a new lawyer. You're not giving me a reason why I should take her off your case.
No, we're having conflict. We're having issues.
I think you're manufacturing the conflict based on what I've heard, Mr. Wagner.
Okay.
Yes.
Why would I?
You're creating the the conflict with your lawyer by saying you want something, but when she explains it to you, you don't really want to do that. And when I've explained it to you, you kind of go in circles, just like Ms. Rivers talked about.
Because I don't know what to do.
Well, not knowing what to do based on the advice given is not a reason to take your lawyer off your case. You have to make a decision. Do you want your case investigated thoroughly, or do you want to go to trial faster? I don't have a problem with putting your cases for trial next time. I would have done it this time, except we talked about it last week, and that's not what you wanted to do. So I can see what she's talking about with this kind of waffling as to what you want to do. And I think I talked about this last week as well. When it talks about a defendant being bound, it means when you say, I want a speedy trial, you're saying, I'm ready. I'm binding myself to that statement. Right?
Yeah.
That I'm ready for trial within the next 5 days. And that's not what you wanted last week when we could have set your case for trial. And I understand you're represented by the public defender's office. Ms. Rivers is set for an all-week trial next week with someone else. So I can certainly try to find a way to give you a trial, but at this point it hasn't been set. So it's not fair to the state either to say they have now quickly sent out subpoenas in a few days based on a demand that was struck last time. So is there any other reason why you think Ms. Rivers has been ineffective in your case?
Clearly, I cannot talk to her.
Well, I don't know what that means.
That's what
I don't think the issue is talking, I think it's listening. I think you need to listen to the advice that your lawyer's giving you and then make a decision as to what you want, just like I've explained these things to you too, Mr. Wagner. And you seem to waffle back and forth every time you come to court. If you want a speedy trial, then we can give you one. I'll set you for trial next cycle. So it'll be in May. And we'll see if we can give you enough 4 trials in that amount of time, because there's just only so many days in the trial period. And you're already awaiting sentencing. Now, in one case, you've gone to trial on, right?
That's correct.
All right, anything else as far as the Nelson hearing?
Denied. Thank you, Mr. Wagner. We'll see you back on April 29th.
Have a good day.
You too.
And then I have Mr. Force with Mr. Klein. Force, Christine,
Your Honor, this is Kevin Forrest before the court on motions to reinstate bonds on these two cases. Basically not going to read the arguments that are made in the bond motion and they're in the motion. The situation with pretrial services, and this has been something that's been a pet peeve of mine for several years now, is when pretrial services files these affidavits, they never serve the defense lawyers. As a matter of fact, at one point, it was in November, probably 2024.
Let me ask you this.
Yes, sir.
Are they required to?
Our position is by due process, yes, because it's resulting in possible revocation of bond.
Have you read Florida Statute 903.0471?
Not prior to today. I mean, I've read it, but
I'll give you my copy.
Your Honor, I understand. I mean, it is what it is. I mean, I'm asking the court to reinstate Mr. Forrest's bonds.
Have you read Parker versus State? 843 Southern 2nd, 871, finding Florida Statute 903.0471 constitutional and not a violation of due process.
I have not read the ruling yet, Your Honor.
It took me 3 minutes to find that statute in that case yesterday.
I've been bouncing around.
I understand, it's just, this is the way it's been done, and it may be a pet peeve, but it's lawful.
I understand.
The court can revoke someone's bond for a violation of pretrial release based on the technical conditions of pretrial release or a finding of probable cause of a new law violation while on pretrial release, sua sponte. What we all have to understand is that pretrial supervision is an arm of the court, right? So they give me the information, and then I don't even have to wait for the state to move to revoke the bond. I can do it myself.
Yes, I know that, Your Honor. I know that the court sua sponte can, but the position that I would take is if the court is relying on a third party in pretrial services, I know
They're not a third party, that's the point.
But my position as a defense lawyer is that then it's not a sua sponte issue, then the court is acting in response to something else.
But pretrial supervision is an arm of the court.
Okay.
And that's, I can't track every person who's on pretrial release.
Certainly.
So we have people who do that.
Certainly. And one of the things, but this is how it causes problems. Previously, and when I was in Division II as a public defender, I had a situation where this happened. And we had an upcoming docket date. I had never been served, so I did not know that there was an outstanding order to take my client into custody, and I filed a waiver of appearance. I would never file a waiver of appearance knowingly if somebody has an active warrant, and I had to tell Judge Brown at the time, like, Judge, this is why this is an issue, because they get filed and we don't get told.
Oh, I understand.
And so I'm asking the court to consider reinstating Mr. Forrest's bonds. I will point out that he received notices to appear for criminal traffic offenses in November. At that time, his truck was impounded. So.
But there's a separate issue. It's not just the fact that he's accused of committing new crimes while on bond. He also wasn't complying with the GPS bond.
I know. Mr. Forrest relates, they're stating that his monitor was in the truck when he got impounded. I know that there's other issues. And
Why did he leave it in the truck? He wasn't arrested.
I was arrested, and they was putting it on the rollback when they said, is there anything in there? So I started trying to get stuff in there. I mean, I was scared. I mean, because it was a citation, and it was the day before Thanksgiving. I mean, I went to Destin just to get an iPad fixed for my daughter so she could have it.
Did you report that to pretrial services?
I told her that when I got a citation. That was in November now, and you signed the an order of revoking bond on January 12th. I checked in with her January 14th, and she said, okay, I'll speak with you. I'll see you guys next week. Me and my wife both was on pretrial services at the time. This is my daughter's senior year in high school, and they're missing both their parents right now. So, and then the charges, I'm really not. I went in the house after my in-laws.
Your Honor, one of the situations, I was not present when the depositions were taken on the armed, more serious case. Reaching out to the public defender's office to get copies of them, I did not know that those depositions were taking place. We did take a deposition in the resisting with a violence case, and the officer in that case testified that Mr. Forrest hit him with an open hand one time in the chest. So Again, I mean,
Case
I'm
number
kind
again, Mr. Klein, 'cause we just added this yesterday, it's on my paper doc. What's the case number again?
The case numbers are 25 CF 1675 and 1676. The 1676 case is the resisting with violence.
All right, go ahead with your argument, Mr. Klein. I'm just trying to
Your Honor,
refamiliarize. I know the case, I know his wife is involved, I know what the facts are. I just wanted to look at the dates. There's just seemingly things missing that should be
so
where I would see it.
we're asking the court to exercise its discretion. I'm certainly not standing here saying he has some sort of constitutional right that his bond is reinstated. If he's
Well, but
released,
that's, the motion says that the court violated due process
Well,
by doing what it did, which is
well, the court's
completely
already-
legal, and the Supreme Court has found that the statute under which it was done is constitutional. So that's kind of where I get to the point of I understand what you're asking for discretion now, but the motion asks the court to reconsider because what it did was illegal.
well, I mean, the court's ruled on that, and so now moving to the portion of the discretion. So Mr. Forrest would be living off of Todd Road, which is just outside of Crestview. His main focus, every time I talk to Mr. Forrest, he always brings up his daughter and how she plays softball, and this is her senior year. I get the genuine sense that he is exceedingly upset that he is not being there for her as she goes through this. And as I believe the court, or Mr. Sprouse had said, the wife is also in jail. So we've got children that have both sets, or both parents in jail. He does have one prior failure to appear. He believes that happened about in 2014. I'm not asking the court to modify any of the conditions that previously been set. He was on a monitor with no issues that I know of from September.
He hasn't been on it for months.
Well,
Right.
He was on the monitor from September, from his release.
Yeah,
And
but-
then he picked up.
January 12th.
But when the new case happened in November, he hasn't been on the monitor since, right?
No, I've been on it. They took it off in jail and they arrested him.
I think he left his charge and died.
When was he arrested?
He was never arrested on the new.
January 15th.
He was-
I feel like this is who's on first at this point.
Well,
When was it?
So
He left the Charger, so, but he still had the monitor on. How was it being charged after that?
I would use my wife's.
Okay. Did you report these things to pretrial services, to whom and when?
I mean, I checked in with her every Wednesday.
Did you tell her that your charging device was no longer in your possession?
No, I mean, I didn't.
Okay, then I don't understand, because what the affidavit was from them, which led to the violation of your pretrial release. Defendant has failed to keep GPS adequately charged and has allowed the device to reach critical status more than 10 times in the last 30 days. The device is now disconnected and unable to track at this time. In addition, the defendant received 3 new criminal citations on November 25th, 25, for no insurance, driving on suspended license, and having an attached tag that was on the side of the vehicle he was operating. So they're saying the thing's not working.
What I would point out, though, Your Honor, is so the affidavit, I believe, was filed, was it on the 10th or the 12th?
January 6th, 2026.
January 6th. So as of January 6th, she's referencing the fact that it was actually it was on at least 10 times in the past 30 days because it had been, the charge had gone down to a critical state. So if it had gone down within the past.
But is now disconnected
Right,
and
I mean,
unable to track.
Right, and I'm not saying that it didn't disconnect, but I don't know when it disconnected, but it sounds like her own affidavit says it was being monitored sometime in the past 30 days because she counted 10 times that it went down to a critical stage of charge. So we're just simple. Look, even if the court grants the motion, I mean, I'm not Mr. Forrest bondsman, but I'm not asking the court to reinstate the bonds and then reduce them to signature bonds. If the court reinstates the bonds, there's a very good chance that he's probably gonna have to repost them, you know? So that we're simply asking the court to consider reinstating Mr. Forrest's bond. And I mean, since I wasn't present at the depositions, I don't know what Mr. Maddox's intent is with the co-defendant here. I don't know if there's any more depositions that need to be taken, honestly, because I don't know who was deposed at this point, but I think the alleged victims were.
Kid hasn't been, the minor has not been deposed. And the offer that I extended to Mr. Maddox was conditioned on not deposing the child and re-victimizing the child. So the 24-year offer, or not 24-year, 24-month offer that I gave, I will extend to Mr. Forrest as well. And that's with me reducing the charges from burglary of the occupied dwelling to occupied structure. Whatever that comes out to is the offer. So I will extend the same thing to Mr. Forrest.
Where's the child residing in?
The grandparents.
Where this happened, allegedly?
The last time I spoke with the alleged victims at depositions, they had him in school at the.
The daughter that's a senior in high school, is she residing with the grandparents?
Well, we need to be correct on which set of grandparents we're talking about. The alleged victims in this case are the parents
Maternal.
of the co-defendant.
Yes, maternal.
Yes. So I believe Mr. Forrest is saying that his children are with his parents now. So
Is there a court order to that effect?
I don't believe so. I looked yesterday in Benchmark and I didn't see any dependency. I mean, nothing jumped
I
out.
don't think you would.
Right.
I don't think you'll see it, even if there was one there. Those are confidential proceedings, so even as his lawyer in a criminal case, I don't think you could see the DP case.
I just didn't see any DP cases that.
What I'm saying is, I don't think you would, even if there was one.
Oh, I see them.
You do?
Yeah, when I pull up Benchmark, I mean, I know that they're there.
The likelihood of there being a dependency case is like really high. I mean,
Well,
The charges are aggravated child abuse.
Yeah, but sometimes they do what's called a non-judicial safety plan, which involves the children going to live with other relatives in order to avoid the shelter.
Right.
So,
I know that the children are not in a shelter, because I spoke with the maternal grandparents.
I understand. All I asked was if there was a court order about that. I don't want to go into whether or not there's a dependency case.
Judge, in the defendant's history, he has other burglaries, so this is no change in the behavior of the defendant. He's still doing the same thing in this case. Very serious. It was burglary of an occupied dwelling.
Do you have a case number on it, Mr. Spence? I know there's a previous
6618 CF 22.
I know Mr. Forrest has been in the department on a grand theft.
So the grand theft was 46, so Okaloosa 16 CF 969. And then in 2018, what my records say is has a burglary of unoccupied structure. And some batteries and some more grand thefts. So the concern that the state has is that Mr. Forrest will commit a new law violation, as he already has, or try to go and have contact with the children, or at least with the victim in this case. Because that's what precipitated the underlying charges in the first place.
I mean, I understand Mr. Klein's, you haven't made this argument, but I know it's often the sentiment that can come off in some of these as well. The new cases are just criminal traffic violations. And my bigger concern is actually the GPS monitor. This is a situation where I think at least initially there was discussion of a pretrial detention. Ultimately there was a hearing, or ultimately there was a bond given with the special condition of a GPS monitor to be hooked up before he ever got out of the jail. And when I have an affidavit that says the thing that you ordered, Judge, to make sure we knew where he was, is not working because he's not charging it and now it's completely disengaged. That's a problem.
Your Honor, can I speak?
If you want to discuss it with your lawyer first, you certainly can.
Mr. Forrest just wanted the court to be aware that, in his words, I don't really understand this, but he mashed the button the night before he got picked up, and there were lights on the GPS monitor, so he assumed it was working. That's what I believe.
Is it not concerned there?
Which son?
I don't have no contact with the victim. That's not in my case. My wife does, but I don't. And I'm allowed to go to the residence.
I mean, the pretrial screening report says no contact with the victim.
Never stated in the court. Your Honor,
I don't believe you at this point, Mr. Forrest. Now you're saying you're mashing the button and it worked just fine.
my son will testify for me. He's seen it.
I think you're potentially admitting to more violations. So if y'all want to get something more thorough from pretrial supervision that says,
I've spoken to
Mr. Forrest, motion is denied. Thank you.
Thank you.
I'm trying to explain it to you. You don't want to hear it, Mr. Forrest, so I'm not going to go any further with it.
Yeah, I just wanted to say that.
There's probable cause that you committed new law violations while you're on bond. You're not using the GPS monitor as required. It's not working because you're not charging it. You've explained to me your charger was left in a car that got impounded because they took it when you got charged with 3 criminal traffic violations. Your bond's denied.
Appreciate it. So my daughter gets to go to high school without.
I'm sorry, why don't you come back to the microphone, Mr. Forrest? Go on back. I don't let people mumble their way out of the courtroom.
Yes, sir.
Is there something else you wanted to say?
So I would say that my daughter's going to do the rest of her senior in high school without her parents there to watch.
Okay. Is she here to say that she wants y'all home?
She can be, for sure.
Well, she's not. And you're currently charged with child abuse against your other child. So if y'all want to put on some actual evidence, you can do that. But frankly, I don't believe you're telling me the truth right now, so I'm not going to take your word for it.
So do I need to call the kids' court?
You can talk to your lawyer about what you'd like to.
I just don't know.
All right. Mr. Ford, I don't know what your issue is when you ask me a question. When I start to answer it, you just start talking over me again. It doesn't seem to make a whole lot of sense. It's not how people have conversations. You just want to be heard, but you don't want to listen. When is he currently set?
He's on the April 29th.
We'll see on April 29th.
Your Honor, I will try to talk to his children. If I file a motion to reconsider, Your Honor, it would only be if I have to talk to them if they're going to testify.
I understand.
So, but I'm in jail and talk to you this evening.
And like I said before I was interrupted, you can get someone from pretrial services here to say this is what the issues are with the device and have they checked it out? When was it explained to them that there was a problem with it? I'm all about hearing it, but when I get an affidavit from people whose job it is to tell me these things, I act on them as required by statute. Thank you, Mr. Forrest.
Sorry, Your Honor.
The only other inmate that I have is Christian Douglas. He's represented by Joe Riosty.
I think y'all finally have an order with the date y'all want to put him on. It was sent to me while we've been sitting.
Yes, Your Honor, I think there was some correspondence going back and forth, and I believe Mr. Riosty submitted an order with May 7th court date at 2 p.m.
Thought that was the date. Let me just get to it. May 7th, 2 p.m. That's it.
Yes, Your Honor.
I guess I'll mention this. I understand there's been a lot of attempts to talk to my office about this from Mr. Riosty. He's been told to do it through email, repeatedly. The email came in yesterday afternoon with this date. I do have the order now, but I think people, until an order is signed, should appear in court. You're here, I know, but I'm just kind of putting it out there. You can also pass on along to him, I don't intend to continue this case again for purposes of the motion for new trial and or sentencing if it goes forward at that point.
Yes, Your Honor.
And then this is a trial that we had months ago.
Yes, Your
And,
Honor.
it's my understanding that there wasn't even a request for the transcripts by Mr. Riosty until this week.
I'm aware of that.
And had I known that, I would have not said I agree with the continuance. I would have just had a hearing today.
I understand.
And
Your Honor.
I hope you don't feel like you're taking the heat for this because that's not the intended. I'm just a little bit perturbed about the situation.
I understand, Your Honor, and thank you.
Thank you. I'll sign that once it's, I get off the bench.
We'll pass on Mr. Douglas that his court date will be May 7th at 2 p.m.
That's what his attorneys asked.
Douglas got him to May 7th at 2 p.m. for his attorney's request. He's done.
Anything else that we have?
I have some score sheets
Oh,
on the approach.
fantastic. Thank you. Anything else?
Not from the state, Judge.
And we will be in recess until 12:30. Do we know how many hearings we're going to have at 12:30?
Tentatively 3. So we have the Cunningham, the Arnett. Then I have a mean with Mr. Klein's.
And I have Hardy, Your Honor, but that's going to be a bond hearing. The state will agree to a bond on that case, or at least make a recommendation for it.
So who's the defense on the two? Cunningham and Arden.
I believe Mr. Williams, Charles Williams, and Mr. Nopes.
Mr. Williams represents Mr. Arnett, Mr. Nopes represents Mr. Cunningham.
Yes, that's what I think.
And you already had yours last week on this situation.
Correct. Rudy Almanza was last week, so.
And I have a different cop testifying.
Well, I hate that it's a situation that sometimes people think I would do, make a decision this week based on what happened last week, but different defendants are differently situated with, and potentially different evidence.
We didn't even try to get the court smart because it's completely different.
I mean, it's just based on the testimony last week. It seems pretty clear that there was different levels of culpability.
Yes, and I think I made that pretty clear last week with your client, Mr. Monk.
Yes. And I'm actively working to try to remove misdemeanor from the pretrial detention docket. I got to talk to Mr. Sprouse here in a minute.
Say again?
I said I'm actively working to try to get misdemeanor off the pretrial detention hearing docket. I mean, she's going to be here. I talked to her 2 days ago, but I'm going to talk to Mr. Sprouse during the recess. And hopefully,
she should be here.
Amasia Amin.
She's not in custody.
No, she's not in custody. So.
Oh, this is the one where it came back with a different weight.
Came back different weight and substance. Yes.
And substance.
Yes.
Yes, so now we have.
Yes, she's been out on bond since October.
There's a reason we can't use jail tests in trial.
Yes. Well, especially with the new substances, it seems to be a crapshoot.
Oh, absolutely. It honestly, like, it seems more often that it comes back positive for fentanyl. It comes back as something else, and it comes back positive on the street as something else, and then it comes back fentanyl. Whatever.
It's because weights, different molecules weigh different things, and it matters at that scale. So when you pull, some
we'll deal with it.
Yeah.
All right. So there's 4 on the docket. We expect there's going to be potentially 2, maybe 3 hearings.
It'd probably be 2, Judge.
And then we only have 10 a week.
Not a lot.
And then I don't think there's anything too difficult on the afternoon. So the road lines. Take some time.
All right, thanks, Judge.
All right,
See
we're
you
in
around.
recess until 12:30.